Welcome, everybody, to this session of Aarohana. Thank you for taking your weekend off for this double delight. Our first session is with Sharada Balaji. Before we begin and I introduce the speaker, I'd like you to go through certain housekeeping rules. During the presentation, all participants will be muted. There will be time for Q&A at the end. Please type your questions in the Q&A box that is at the bottom of your screen. Stick to a specific question. Please mention your name and your background, where you're coming from, what's your designation at work. If we cannot answer your questions during the session, we'll take them offline. Please email them to us at aarohana@niceorg.in. Certificates of participation will be issued at the end of a 3-month program. We are tracking your attendance. A lot of you have been writing to us for the same, so don't worry, we're keeping a track of your attendance as well. You can visit our website, niceorg.in, for more information about Aarohana or NICE. Feel free to invite your family and friends to catch up on the session through our Facebook page, where it's being streamed live. You can also please in fact join our LinkedIn group, because that's where most of the communication will be happening during and post Aarohana as well. And these sessions will be uploaded on our YouTube channel in a few days from now. With that, let me welcome Sharada once again. Sharada is the founder of Nova Juris Legal, a law firm that has worked with corporates, that have worked with startups, multinationals, high impact growth and businesses. So they specialize in technology, law, intellectual property, much more. And I'm going to leave Sharada to talk about it. So Sharada, welcome. And the stage is all yours now.
Thank you. Thank you so much for NICE having me here. And thank you, Sanjay. It's a fantastic initiative and India needs a lot of it. Thank you, participants, for being here. For spending the time on this heavy subject on a weekend. Queen's Gambit on Netflix is really nice. I'm waiting to hope to see the last episode of it. And I'm happy that you're treating this session over on Netflix. I'm here to talk about legal basics. What I do understand, one second, let me share my screen. Is that fine?
No, we can't see your screen as yet.
Strange. Share.
Yeah, now we can.
All right. So I'm going to take you through some of the basics, legal basics. I've been given quite a lot to cover, but there are some that I I think there's a lot of material already on the internet. So I will skip those or run them very quickly. Um, like I said, I'm happy to be here, and I understand most of them are still planning to start on your own, and most of them are tech enabled businesses or looking at tech to enable your non-tech business, if I may call that. So let me take through the first one. So about Novo Juris, we are about 12 years, Bangalore, Bombay. We work across, with the tech world. The world is a small place. We do have practices of setting up funds, Mauritius, Singapore, India. We also do the investment from the funds, and we've done more than 450 of them. We typically do about 40 to 45 in a year, which makes us India's top 10 when it comes to private equity. We become the legal department for many of these companies, which means, well, even before starting up, they think of what needs to be done in terms of, say, IP or product positioning, etc., or way to set up. We typically do India, US, and Singapore largely. And then through the journey of them setting up, becoming their legal department, compliances, house in order, be diligence ready, fundraise, post fundraise, relationships with the investors, between the founders themselves, as the teams scale from 1 to 10 employees to hundreds and thousands of employees. Many of those exits of founders, exits of employees, M&A of all kinds, entity buyovers, equity, stake sales, takeovers, mergers, amalgamations, dissolutions, the sad story of just winding up. We've done it all. And while we largely work on tech businesses, which is, I use that word very broadly to mean um, media, SaaS, cloud, data, analytics, health tech, fintech, edutech, um, largely those. But we also work in, say, medical devices, manufacturing, setting up of those, especially in Genome Valley, and across a wide range of industries as well. So that's us. Um, Let me go to the first uh, topic. This is, I'll quickly run through this because I think most of you would kind of know there are largely a sole proprietary concern where it's just you as an individual starting off, and you would perhaps have a different name for your enterprise. It's just an individual, but that does not mean you can't scale up. You can have thousands of employees as well, still as a sole proprietary concern. You can have the bank account in that separate enterprise name. It's unlimited liability. The taxation is largely based on personal tax slabs. So it is the individual running the business with a separate name, can scale to any extent, but it's not fundable. And I'll tell you why. Then there is another format called the partnership firms. It's more than an individual and less than 20 people. That is what our Partnership Act talks about. It's not a separate legal entity. It's called Association of People. And you get to register the partnership deed with the Registrar of Partners. With the registration, it gives the ability to sue. You can always be, as a partnership firm, it can always be sued, but in order to ability to sue someone, say money not received and you want to issue a legal notice, etc., it has to be a registered partnership, and it's unlimited liability once again. And the partnership deed is the determining factor for the contributions, profit and loss, who takes the decisions. The managing partner, like the CEO, the managing partner is responsible, holds out to the world that managing part as a managing partner, he can and has the ability to take decisions on behalf of the partnership firm. Now, if one partner were to go do something, then all the other partners in the partnership firm are liable, and it's unlimited liability. The taxation is about 30%. Yeah, surcharge and indexation, loss charges, charging of losses, etc. But the taxation is about 30%. LLP is a cross between a partnership firm and a company, limited liability, separate legal entity, which means it can own its own assets, have its own name, distinct from the partners themselves. They have something called designated partners, minimum of two, to start a LLP. It can be any number, there's no maximum. The taxation is about 30%. Earlier, they had a lot of benefits, such as, and I think it still continues, wherein it can have an uh, audit taxation beyond 40 lakhs, etc., etc. Earlier, it was taxation at 30% and no dividend distribution tax. And it was very, very, compared to a private limited, many small businesses not not wanting to raise money used to go with an LLP structure because of the tax benefits. However, that thing has changed because in a company, the taxation has kind of gotten reduced. The enterprise tax is about 25% with a surcharge. And of course, the less than a turnover of 400 crores, then it's a company. The reason why company is very interesting, and it is the only choice if you want to raise a fund, if you want to do a fundraise, be it angel, seed, institutional, venture funding, many a time even venture debt, is that it gives the limited liability, of course. It's a separate entity, of course. It can own its own assets, of course, but the the fact that there can be a separation of management with the ownership, management of the company is through the board of directors, wherein it's one person, one vote, versus shareholders, which is one share is equal to one vote, right? So for an institutional investor who wants to control the company, not as a decision making or anything, you'll as founders you'll still be the decision making people running the show, etc. But they have a better say if they can participate at the board level and control on everyday decision making, and still hold the 20, 25, whatever is the minority shareholding in the shareholding percentage. So that's the reason why company is the choice when you want to raise money for your scaling up. Founders agreement. So you thought of setting up. You will also think whether you need to be in India. Most traditional businesses. Pardon me for classifying non-tech as traditional, but it's just for a ease of communication more than anything. So for traditional businesses, um, the operations is largely in India. So I'm guessing most of you would be set up as business in India. But what we are seeing as a trend in tech business is that um, they get to see and expand to other geos from say Singapore to South Asia or whole of Asia to say UK for whole of Europe and US for the US continent itself, right? So that's something that you'll have to keep in mind. If you want to go the same way, then you'll have to think whether you'll need to have, apart from India, would you like to be present in any other jurisdiction as well? Founders agreement. Now, when people come together, it's very important that the arithmetic of who owns how much shares, who will dilute how much, what is the investment from one partner, one founder to the other founder, what is it that you set aside for ESOP, etc., has to be discussed. Now, well, for founders to come together, it is usually the chemistry, you need to be able to work with that person, able to bear completely and transparently on everything business, right? The fears, the tribulations, the joy, the upsides. You should be able to share everything, right? So therefore, the chemistry, I always call it as the chemistry comes before the arithmetic. Arithmetic will kind of fall into place, but if the chemistry, the ego, the style of working, etc., doesn't gel, somewhere you'll see the cracks in the between the founders itself when communication kind of cracks. Now, the typical question that gets asked is, how much should each founder hold as shares? There's no magic formula. It is largely dependent on the function of the business. Now, say for example, if it is a um, if it is a tech product, for example, then the person who is responsible for building the technology will hold a slightly higher ratio of shares compared to, say, a founder who does just the operations. Yeah. Now, you can always question, and this, in terms of roles, responsibilities of the founder, many a time I have seen change it over a period of time, right? Now, I can take the example of Practo because I worked with Shashank when he was in still the final year of engineering, and they built the entire stack in the final year of engineering. And the guy who built the tech stack finally decided to move out, but he wanted to hold the large percentage of shares when he wanted. Now, when he held a large percentage, and if he is moving out, then how do you determine the whole ratio of who does what and how much shares, etc., becomes a problem statement. So think of this founders agreement not only as putting together the house in order, uh, clearly, uh, in a transparent way, having that uneasy conversations upfront on everything that builds a solid foundation for a long haul, but also as a prenup when things go wrong. So how do you treat the shareholding or the directorship or the employment of the leaving founder? Yeah, that's the reason why you need to have a founders agreement. So I would urge you to go through this link called founders.com, founders without the E, founders.com. They have a nice matrix of, decision making, how many people, etc., which helps you arrive at what that shareholding percentage could perhaps be. But it's more a gut feel more than anything. But definitely, it's helpful if there is one predominant founder, because then the decision making, etc., kind of helps. Um, the initial and the future investment amount is a question that you will talk. If someone were to not bring in the money, or in the future does not bring in the money, then there is a dilution. You wouldn't promise, the founders definitely wouldn't have a conversation saying that I'm 20% forever, you are 40% forever. No, that conversations don't happen. You will say, to begin with, this is how we will be. Now we may have ESOP, therefore we can have early employees coming in, and we can give them stock options, because the early stage company wouldn't have money to pay market salaries. If there is a future investment comes in, then everybody dilutes proportionately. So that's the kind of conversation. So people the founders will keep diluting the shareholding percentage. The number of shares remain the same, but it is the shareholding percentage that keeps diluting. Yeah. Now, there is a concept called, in the tech world, we have this concept called vesting and reverse vesting. What it means is the founders are coming together. They continue to be the founders, don't get me wrong. They continue to be the owners of the shares. The economic benefit gets spread over a period of time. What it means is the founders will have to, though they are owners, they'll have to earn the economic benefit over a period of time. Typically, it's 4 years, and the vesting is monthly, quarterly, annual. You could discuss, and this is helpful because assuming you come into picture at say if someone were to leave in say 1 or 2 years, then it helps to arrive at, will he get to retain the entire shareholding, will he have to transfer back certain shares, will he what do you do, right? So that is where, if the founder is separating on a good reason, uh, that which is not bad is good reason, um, then typically what we say is he continues to own everything that was vested shares, and at market value, because he gets to earn the upside through an economic benefit, therefore the market value. The unvested goes back either to ESOP or to the continuing founders at face value. uh, the bad lever is typically all the bad reasons that you can think of, right? Did not perform, did not uh, contribute, um, um, morally not right, swindled money, there was theft, caused a rift amongst employee staff, those kind of willful negligence. Those kind of things is what we kind of typically call as a bad liver. Now, when you have these conversations between good liver and bad liver, it builds a lot of trust between the founding team, because then each person knows how their shareholding will be and what happens if they were to leave. So that kind of helps put that foundation for a very strong trust as well, right? And in a bad labor, because there has to be a penalty, what happens is all the vested and unvested shares comes back at face value. So there is no economic upside, but there is a face value, which is typically the 1 rupee, 10 rupee per share. It is that, it's the face value. Okay. Now, what do you do with these shares? It can be, it can go back to the continuing founders, but there could be a problem with that, because then the continuing founders may think that, they may just want to elbow out a leaving founders, therefore they could garner a higher percentage of shares in the company. Does not give a good equation, does not give a good transparency. There is always that, you would make the founder kind of look at the backside all the time. So usually not a good thing. What we do is try and push that into stock options. Therefore, it helps with a new incoming founder, or helps uh, building ownership with the early stage employees who kind of start behaving like ownership, because they'll also have skin in the game, right? So that's the reason why typically vesting and reverse vesting happens. So you continue to be the owner. If some bad reason happens, or want to separate, a founder wants to separate, then how would the number of shares or the percentage of shares come back, and at what price? Now, the intellectual property, or dependent on what's the kind of businesses that you are or will be in, um, all of it belongs to the company, which means all the assets belongs to the company and not to an individual, including, say, a domain name. Novojuris.com, for example, belongs to the company, not to an individual. Yeah, make sure. And founder separation, not a pleasant one, but it can be made pleasant or made amiable, amicable, if you have this kind of a founders agreement in place. Yeah, there are three roles, distinct roles that each founder plays. They are a director in the company. They are also employees of the company or the business, and also the shareholders of the company. Now, if they are leaving, then of course they need to resign as an employee and directorship. And how you treat the shareholding, we just discussed now. They continue to be responsible for all liabilities till the date of separation. So, and do it in a way, the process should be done in a way that the knowledge transfer happens smoothly, all the trade secrets, and how a business is run at a very, very intimate level is what a founder would know. Therefore, try and see if there can be clauses of no disparagement, don't start competing business, no further claims, etc. And many of them do have this point in their mind, whether non-compete is legally tenable. Yes, it is. And there are ways to make it legally tenable, especially at a founder level, because they have the intimate level of detail, which we call as trade secrets. It becomes legally tenable, right? Saying that if this person who knows so much about this business goes and starts a competing business, will cause harm to to the business, then it's legally upheld. Yeah, and give a thought to some of the other things such as designations. It may seemingly look inane, but if the moment a person is called a chief executive officer, guess what? All the decision making kind of goes to that person. Or if there is an incoming investor, there can be conversations that just goes to them. And I think I distinctly remember Let's Venture Shanti, when in her previous startup, she was saying this. It just so happened there were three founders, and they discussed over a coffee table, saying that I don't want to be a CEO, I don't want to be CEO. The third person had to, by default, became a CEO. And during the fundraisers, they realized that the investors were talking only to the CEO, while all the three founders were equally responsible for the decision making. So sometimes these do have uh, different unknown issues that may come up. So typically, as lawyers, we would have seen over 1,000 startups, right? We get to pick and choose what is relevant, what needs to go in. Therefore, it's a balanced document. We make sure that the founders open up and speak on all of these concepts, and it goes into a founders agreement. So we distill all the nice essence of what we have seen and what can go wrong, and try and put that into a founders agreement. For example, bank account authorizations. Can you just trust one person? Do you think there should be dual joint signatories? Uh, are the conversations? Directorship. Should all the founders be on the board of directors? Maybe it works while you're starting off, but should there be institutional investors? They typically have a ratio, right? A 3:2 or a 2:1, that kind of a ratio. Then some of the founders may have to step down, which, you know some people may look at it as a demotion, while it's not, right? So those are the conversations that you need. It's better to have upfront, or think of it logically and say, should all of them be on the board? Um, I, when it also depends on the director, on the stakeholding itself, right? Um, a lot of factors go into that kind of a decision in terms of directorship. The decision making per se in terms of how to run the business on an everyday basis is what goes into the decision making. Can a person who is responsible for sales and marketing have a say in how a product should develop, or can they have a say on where the store should be located? Can they have a say in the costing? You know, those are the things that you will kind of have that conversation upfront. And very important is the roles and responsibilities, who will do what. And therefore that element of accountability, the element of the ability to take those decisions in that area becomes easier. So this founders agreement, think of it as a foundational document for a long haul. I mean, if I were to draw a reference, if there is a divorce between the husband wife, it gets ugly, right? The child also suffers. Into 10 times is what happens when a founder were to leave. So it's much more, because, and also you'll be emotionally invested into the business as well, because you're passionate and that's why you started. And therefore, so think of the founders agreement very carefully. If you have questions, feel free to drop it in the chat. I'm gonna take a lot of time, at least about 20 minutes to answer the questions. Employment agreement, I'll rush through this. Um, the, I mean, most of you would either have been an employee, know what employment means, or would have started a business and have hired employees. So I'll rush through this. The initial employees are crucial. How do you incentivize them? Therefore, you can retain, reward, recognize, compensate, or incentivize them is through the ESOP mechanism, especially when there isn't enough money to pay market salaries. The entire set of documents is not just an offer letter, but it's a set of offer letter, what you put in employment agreement, an employee NDA, a service bond if you want to retain somebody for a longer haul, the employee policies, the IP, prior IP declarations, etc., are all forms a complete set of employment. So think through all of it. All these documents should talk to it, should talk the same thing, right? Should be important. So also is induction. While you would have taken a lot of time to hire the employee, choose and hire the employee, um, making that person come and join will will determine the culture of the organization, especially the initial employees. They determine the culture of the organization. So the induction, therefore, they kind of really gel into the culture that you want to build is important. So is exit, because the employees are brand ambassadors for the organization. So the moment you think of it as brand ambassadors, then both induction and exit becomes crucial. We are also seeing a lot of attrition. I don't know about non-tech business, because non-tech, it's a large area to cover, from textiles to yoga to jam making to, it can be such a large canvas. So I don't know about the attrition rates, but what we are seeing though as a country is the I come from a previous generation of sorts, where we used to typically work for 5 years in an organization, to now it is about 1 year in an organization, and many a time it's much lesser. What I also see, and perhaps Sanjay also should take this up at some forums, perhaps, is um, if a if an employee stays for a year, after the year, it's a performance appraisal hike based on the performance, right? But if there is a change of job, it is usually industry practice of taking it at a 30% hike. So Perhaps one of the problem statement in India is this, attrition is for this 30% hike as an industry norm. The incentive policies are very important. What you measure is what you get. You need to think of these incentive policies carefully. And each industry, how you measure what you measure is also very different. Some of the clauses that you will need to think of is the non-compete, which means you cannot go join or compete in business. At a lower level of employees, it's still okay not to have it, but as you have mid-manager and top management, non-compete becomes crucial. Non-solicit, which means um, if you left the organization, since you know who works and what their competencies are, don't solicit those people for your for that person's, the leaving employee's next gig. Data protection, we are seeing this take a very, very important twists and turns. Let me take an example. Um, there could be a entire customer database, right? Now, how do you protect that? It could be entire, say, for example, textiles. It could be the color gradation, or it could be the texture so unique that you brought in, or it could be, I'm working with one yoga company where they have this sensors in a yoga mat, um, and how they place the sensor and the reason for placement of such sensor. I mean, if it's out in the market, it's out in the market and anybody could use. But the thought process that went in is still important data, right? Which is called the trade secret. Now, how do you give access to trade secrets? How do you manage, monitor, or restrict the access to trade secrets is something that you got to think about. uh, there is a positive power of the social media and a negative power. What we have also seen is employees, and I have dealt this as a lawyer, is if you do not choose to take them as an employee, they go leave a bad Google rating or a Google review, or they write bad in Glassdoor, even though they haven't worked in the organization, or leave in some of the social media, right? So that's something that you have to be conscious of. And there is also, I mean, LinkedIn is nice because it doesn't allow anonymity. So it's nice from that perspective. Therefore, what you see in LinkedIn is largely positive. Think of what it means when someone were to join competition in spite of having all of this clauses, then what would you do? And that determines what messaging you give to the employees who continue to be in the organization. So as founders, you'll always be watched, right? So what steps you take, what message you give, what is it that you go very strongly on determines a lot in terms of culture. IP, I will not take a lot of time because because it needs a lot of context to talk about IP, but I'll kind of talk about what kinds of IP, right? Patents, copyrights, trademarks, geographical indication, perhaps in the non-tech businesses, you'll have to think of it. What geographical indication means is, think of it as basmati rice, or uh, mus- sorry, what is this? There is a kind of a rice that you get in Andhra Pradesh. Um, those kind of are called as geographical indication. It could be the Champagne, which is a place um, in France. So those are called geographical indications. Semiconductor, which is largely, I'm not too sure if it's applicable in this context, in this forum. Trade secrets. Trade secrets is that which is confidential and has an economic value, and it gets protected through a non-disclosure agreement, which means you can, as long as it is kept as a secret, then you can retain it. A beautiful example, it's always spoken about, is the formula for Coke, the Coca-Cola. Now nobody knows the trade secret, it's not patented. So It's not in public domain, and therefore it can be economically exploited. Exploitation is a word that is used in IP. It means how do you use an intellectual property to exploit and make money, right? It's called exploit. So you can exploit a trade secret's economic value, economic benefit over any length of period, as long as the management of confidential data through non-disclosure agreements is managed very, very well. Patents is for inventions, that which is useful, novel, non-obvious. That which is already there in the market, where you get to search, which is called prior art. If it's already there in the market, which means it's not novel, which means it cannot be patented. It is the strongest form of protection because it gives a negative right. All IP is a negative right. What I mean by that is it is mine, nobody else can use it. So it gives a negative right. And all of these are jurisdictional. Um, Other than trade secrets, which is not registered, everything else is registered, and it is a country level registration. So it's a India patent, India trademark, India copyright. And if you need to go and use that in, say, US, you need to go protect that in the US, or protect it in Singapore, or protect it in France, for example, right? It gives there's a life of 20 years. You can't renew a patent after 20 years. It just goes to public domain and anybody can use it. You can do a worldwide patent also by through a patent trade office filing. Yeah, there is a product patent, a process patent. A process is a lower version of a product patent. What I mean by that is product means however, whichever process is used, the patent is the patent owner's. Whereas process patent is largely, which is what we had for our pharmaceuticals in this country, which means it is only the process which is patented. Now, if someone else were to use a different process and still arrive at the same end product, it would not be protected. Uh, in India, software is still not patentable, but there are ways and means of how you can make software also patentable, which if I can give an easy example, if the software makes a difference to the hardware, then you can have easily, it can be patented, provided, of course, useful, novel, non-obvious, and an invention is proven. The next is copyrights. In patent, it's an idea, product, etc. Right? In a copyright, it is an authorship. It's the original work which is protected, and it should be on a medium that is fixed. Either as a video, voice, paper, whatever medium, it has to be fixed on a medium, and that is what gets protected as a copyright. And it can be a range of things, right? Like books, music, painting, sculpture, poetry, drawings, advertising, any of them. And there are different timelines for protecting. So for example, if it's a literary work, then it is 60 during the term of the author and 60 years thereof. If it is a anonymous work, then it's about 120 years, things like that. So it's a very different timeline for each kind of um, copyright. The next is a trademark, perhaps very relevant for this forum. Is trademark is um, the name, logo, brand, tagline that you see, right? All of those are protected under trademark. It gives a 10 years and it's renewable. Trade secrets we spoke about. And if you have any questions even on IP, please leave it in the chat. I'll pick it up. Choosing a lawyer, I would like you to read this. This is from Naval Ravikant, the founder of AngelList, where investors can come together, pool their investment to invest into a company. He's a billionaire, and this is what he says. Uh, when you choose a lawyer or a law firm, try and choose a smaller firm because the accountability is extremely high. Bigger firms, he says, all other things being equal, are generally worse, is his observation. That's because The the main partner is involved in business development, and the moment the client walks in, then it gets delegated to a junior. And that, so you're typically working with a junior when you go to a large law firm, versus you work with very senior people who can add value to the business when you go to a smaller firm. That's the point that he was trying to make. I would urge you to read this link that I have pasted here. It is also helpful when you are actually doing recruitments for employees as well. He makes some really beautiful points here. The other thing that you will choose a lawyer is a lawyer who understands your business with not much of explanation required from you. And typically the first meetings are complimentary. So you can use that complimentary time to actually understand the lawyer's capability, capacity, expertise for your kind of business, right? Uh, for example, if I may talk about myself, I love to work with uh, younger organizations compared to a mega corporations. A mega corporation will need something called compliances to competition commission, right? An antitrust equivalent in India. I don't specialize in competition commission, but I understand young organizations requirement which scales up to say 5, 6, 10,000 employees. I get that extremely well. So each lawyer have their own strengths. You need to figure that out. Test the responses on the first call, and that should be a very good one for you. And as founders, you are supremely smart, right? So you should be able to get that. And quality comes with cost. And what is cost? Cost is not just money. Many of them equate cost with money. No, it is time, effort, money for you to fix, refix, or live with a problem uh, through the journey of the organization and the impact that it may bring. A small problem could also lead to a big issue itself. And let me narrate a story. Um, we have a ton of compliances in this country, a ton. Um, this organization so happened that whenever you raise money from outside of India, there is a filing that goes with RBI. It's called a form FCGPR. What it means is we have received foreign money, and at some point, this money has to go back, repatriate. Now, this organization had forgotten to file that FCGPR with RBI. Now there was an acquisition, and it was a international organization acquiring this. And now, because the FCGPR is not there, they could not repatriate. This compliance can be fixed. It's about going to RBI, and there's a process called compounding, where largely what it means is, sorry, boss, we made a mistake. Here is the penalty. For an Indian entrepreneur, given that we understand the how easy, difficult, or the number of compliances, we understand. But especially for a foreign investor or an investor who is or an entrepreneur setting up business for the first time in India, then it becomes very, very scary situation, if I may call. So this deal fell through. This acquisition fell through. Though we were representing the investor, though we told the acquirer that um, it's okay, it's fixable, they just read the law where it said there is also imprisonment, and they backed off, right? So that is what I mean when I say quality comes with cost. You need to take, and quality work comes at a slightly higher price as in money, right? But it saves you from time and the effort to fix those issues at perhaps 3x, 4x, 5x, 10x cost. That's how you need to think of. A good way to approach and appoint a lawyer is references from other entrepreneurs. Don't think of lawyers as them and founders as us. Um, it is us, right? Just as you go to a doctor or you need to talk like that to a lawyer, because if you withhold information, a lot of what advice we give is very context dependent, very fact dependent. So it is very important that you have that comfort built with a lawyer, and look at it as a long term. Niche versus full services we spoke about, and also the fact that you are so busy running your business, ensure that you don't have to do a follow up or reminder with your lawyer, and they are responsive and they are accountable. So that's how I had to share. I have another 16 minutes to go for questions. Over to you, Arunima.
Thank you so much, Sharada. A very insightful session. Uh, Without delaying further, I'd move on to the first question, which comes from Krishnan, Anant Krishnan from Facebook, and Sridhar also asks this question. If you could elaborate on the pros and cons of one property, one person ownership versus sole proprietorship.
Okay, so OPC, oh, I'm glad you brought it. I did not include in my slide. So OPC gives a limited liability. It's a sole proprietary, largely giving you the color of organization, and that's the benefit of an OPC. Um, but in terms of everything else as compliance, etc., be it labor tax, other kind of compliances, it's still the same, but an added compliance of filing with registrar of companies too. um, but but otherwise I'm not seeing a lot of difference between a sole proprietary and an OPC.
So, is there any particular way entrepreneurs should go about when they're founding their companies? What should be their
So the if it is a lifestyle business, then perhaps a sole proprietor. If you're just an individual, you can always be a partner the moment you get to another partner, or if you already have a partner to begin with, then you will be, of course, a partnership firm. Between a partnership firm and an LLP, because the taxation is still the same. You could be an LLP, but an LLP will have an added layer of compliances with the ROC, because every time you make a change to the partnership deed, the LLP agreement, then you have to go make those filings with the ROC as well. But guess what? Because the law provides for a lot of things. You don't, even if you were to miss a small piece in the LLP agreement, the law picks it up. Same with the Companies Act, right? Even if you were to miss something, the Companies Act provides for it. So you wouldn't have to put all of that in the memorandum and articles of association. So that's the advantage.
right, right. Thank you. Mamta asks a question. What is vesting? If you could elaborate on it.
Okay, so the example that I'm taking here is a private limited company, and which has shareholders and shareholding. And so Mamta and Arunima are two founders in that company. Both of you are 50-50% shareholders in that company. And now Arunima wants to leave. Okay. Now, the point I was making is, should Mamta continue Arunima hold those shares even though she leaves the organization? Right now, so what do you do as Mamta? You will say, hey, you know what, both of us are coming together, both of us are owners of 50-50%. However, over a 4-year period is how we will earn the economic benefit. Now this 50, so 25% each is what we'll say. Now if Arunima were to leave in 1 year, she has earned only 25% of her 50% share, right? So she can continue to be the owner of the 25% of the 50%, right? And the remaining shares comes back to Mamata. This process is called vesting or reverse vesting.
Right. Thanks. That's very lucidly explained. Mamta, hope that's clear. Bhavna asks that if she would like to hire somebody from a marketing background as a co-founder, what are the liabilities that he or she will be responsible for? What
As an employee and liability,
as a co?
uh,
That's the
As a
question.
co-founder.
As
Okay.
a co-founder, yeah.
Okay. Um, so in terms of a sole proprietary partnership, it's unlimited liability. So even if that marketing person did something not okay, then the other founder is also responsible. In a LLP, it is limited to the LLP, the entity. So is the company. Now, in a LLP or a company, it is the liability is limited to the capital in the LLP or the company, capital in that entity. There are some exceptions. Say, for example, there are some criminal act. For example, uh, our legal metrology act in this country has a ton of clauses which provides for um, imprisonment, right? Or the packaging rules on a physical product has to be in a certain way. If you don't, there are some imprisonment. There is a check bounce. It's a criminal act. These are exposures, and it is not limited liability.
Right, right, right. Thank you so much. I think Bhavna would have more clarifications, so we can take it offline as well. Moving on, just before we continue forward, I just would like to digress a little bit and share my screen for a while to inform the participants of our next program, which is the business plan competition that will begin in January 2021. It'll be a month-long program which will end in a prize money over three ranks, the first, second, and the third. So please stay tuned. Watch our website. I'll also be informing you over an email about the business plan competition. Feel free to apply and also ask your friends who are not necessarily a part of Aarohana. They can also be a part of it as well. Uh, that's from my side. Moving on to the question and answers. Sharda Namrata asks, businesses more successful when founders are related to it's better otherwise. I'm not sure what this really means. Namrata, if you could clarify it again once for us. In the meanwhile, Mamta asks another question regarding IP. So she says that design registration is missing in the slide. Is there any specific reason, such as bamboo toothbrush? Can that be patented? Or would it be more if bamboo is patented under a geographical indication? Uh, and
Bamboo is not geographical indication, Mamta. If it is a bamboo toothbrush, then of course you can go through a design patent because a design, um, so there can be a design protection for the look feel, for the bristles, for the shape of the bristle, for the shape of the hole for the toothbrush. You can protect all of it through the design protection.
right. If you could just talk a little bit about what is the process of patenting and how much time would it take to register a patent in India, get it approved?
Okay, it starts with what the invention is about. We typically, as an internal process in Novo Juris, we have something called an invention disclosure form. It talks about the invention at length. The next step is, that IDF, invention disclosure form, helps the inventor also to think through the invention itself, so that they put the entire concepts, the length and breadth of the invention also in a very cohesive way. And then there is a prior art search, which is um, a search that is done across databases across the world, not India, across the world. And then that patent, after the prior art search is cleared, which means there is nothing that infringes or same as the other, then there is a prior art search clearance that you get. And then you go and draft the patent. Now, if all the aspects of the patent are not yet satisfied, you can do something called uh, a you can have a 12-month time from the patent filing to come up with the complete claims. Once all the claims are done, is the patent filing done? You choose the jurisdiction of where the business will be. And then about 18 months is the time for the examination to come up. You can always choose for a faster examination. You need to make a form filing. Once the examination is done, through the examination process, the examiner can come with a lot of questions. You need to keep answering them. Once that is done is when the patent is granted, or you will have to provide additional uh, um material, if I may call, or additional proofs that we may call for uh, for standing by the application that you have made. So that's your total patent process. In India, it's kind of taking about 5 to 5 years or so to get the patent application. But if you have a really good smart law partner, you can get it a little faster, because then you make those applications, you follow up with the patent office, etc.
Right, right. Just an adjoiner to this. So if you could compare between the product process and utility patents, also when it comes to design, so if you to patent a design of a board game, for example, how would
How
that?
can one protect a board game design globally? Huh. I think it's a lot to do with um, copyright rather than a patent, Rohan. The rules of the game and the board game way, look, feel, etc., is a lot more in terms of um, copyright. In terms of, I mean, if there is a one level, for example, we have helped triple IT professor to patent a reverse chess game, um, because it was so unique an idea that we were able to get a patent. In your board game, we need to think of that aspect as well.
And when it comes to processes or utility or services, can you patent them as well? And what's the process?
If it's a process, yes, you have a process patent, but it depends on the uniqueness of the process itself.
Right, right, right. All right. Just moving forward, Kavya asks, after we register a company name and a logo, there are always others who have same names. Google search throws up their names too in our searches. How does one manage this situation? Is that, I think this is more of an algorithm.
No, what's the name of the person who's asking the question?
Kavya Money Mudra chosen.
Okay, Kavya. So all of this intellectual property provides a negative right. So if you, the way you would choose the name Kavya is you can defend it. Now, can you go? I'll just take an example. Now, can you go and trademark Kavya? Now, assume it's not possible because it's a common name, and there can be others as um, you can call it a poem, you can call it a girl's name, you can do multiple other things. So, can you trademark it? Perhaps no. Now, assume you did. Okay. Now, you should have the ability to go and stop someone else from using it, right? The way you do it is send a legal notice, of course, for saying, hey, this is my trademark and you cannot. So the trademarked name gives you the right, as the holder of the trademark, it gives you the right to stop anyone else from using it. Now, it's not just the question of winning the trademark, right? It is also about defending it in the real market. So try and get something unique, therefore you can defend it.
Right. Just a few other questions, one or two before we end the session. Mayur asks if you could refer some reading material to help understand copyright law for visual creatives such as photography and what's the way to go about patenting them.
So WIPO itself, WIPO, their their website has a ton of resources. I think you can check it out.
Right. Thanks. That will be helpful for all the audience. Then We have so many questions coming in now. Uh, Wilson asks, he has a situation where he had a private limited company with two directors, one of them being his cousin, uh, and who one day decided to resign, submitted his resignation. And now his company is only with one director for the last year and a half. Can he predate and include a director, and through though can he continue file his IT and GST returns? He's not sure of the status of the company because he understands that a private limited company should have a minimum of two directors. So what does one do with one director?
Send me the question because you are asking a ton of things here. Email me the question.
Yeah, we'll do that. Perfect. Okay. All right. So just last question here. Uh, that from Vijaya, who's formed a private limited company for marketing products of producers. Uh, how can their interest be protected in the marketing company?
What interests?
Vijaya, would you like to elaborate on that again? So because they say that they formed a private limited company for a marketing products of producers who are formed as producer company. I think we'll have to take this offline as well. Vijaya, please write to us on this. Um, Usha Venkatesha asked that are there any tax holidays for proprietorship firms, which is a startup and involved in imports?
None. There is this Startup India program. Can you just take a look? I'm not too sure if sole proprietary is covered there. I know for a fact LLP and companies are covered. I don't think sole proprietaries are covered. But if not, then no tax holidays.
Right, right, right. I think that's the questions we have for today, and we'll continue some of them offline as well. You can always write to us, and we'll forward them to Sharda. Uh, Sharda, you could just collate the answers and send them. So we'll put it out as a blog on our website. With that, thank you so much for this session. A lot to learn, lot to read upon as well, for entrepreneurs who are starting out, get a legal insight and consider many other things, once we start with that. Thank you once again.